Good morning. My chosen topic is contract data. The reason for this is that I'm still seeing instances where users are making mistakes and getting confused. And I thought it'd be good to have a chat about why that might be, what the consequences are, and why people are getting it wrong. We also have a really high quality, well-informed audience here, and I thought it would be an opportunity missed if we didn't get some output from this, hence the handouts. So as I go through the presentation, we're going to have a talk about some of the areas that I see users getting it wrong, and I'd like to get some feedback from you. If you've got a pen, I think the idea is you circle one of the answers and we'll collect them back at the end, and I'll just really be useful for me to analyse that data and see what a highly informed, experienced audience thinks of some of the questions. Now, I don't want this talk to be interpreted as a drive to simplify or dumb down the NEC. We all know it's an excellent and sophisticated form of contract, and we get a better performance from it as a result. We can't cater to the lowest common denominator in terms of simplicity, otherwise we would lose functionality. So I'd like to think about that as we go through these questions, about the loss of functionality if you were to make it more simple against the benefit of the complexity and the sophistication that we have. Okay, first item, what is contract data? Well, you get various answers if you ask this. Part of the contract providing details of the agreement reached. That's what it says in the guidance notes. Part of the contract providing data as required by the conditions of contract. The conditions of contract can't operate unless you put certain data into the contract data. That's also what the guidance notes says. 13 pages of multiple choice data entry, many of which are option dependent, requiring a good understanding of NEC3 ECC to complete, or at the very least a recognition of the commercial significance if you get it wrong. That's not what the guidance note says. That's my words. Okay, so where do I see most of the mistakes getting made? Well, to be fair, it's mainly in contract data part 2, completed by the contractor. Now, these observations that I'm making today aren't all from main contractor level. In fact, a lot of the mistakes and misunderstandings I'm seeing is when you get procurement at levels 2 and Tier 2 and Tier 3. If you went back 10 years or more to the days of NEC2, there was wide-scale confusion that I saw in completion of contract data. It's got a lot better. There's a lot of training, there's excellent guidance notes, and at main contractor and client level, I think we're getting pretty good. But if you start to go down to second tier, third tier, you will see there is mayhem at times. Okay? So, in terms of contract data part 2, the majority of it forms data for schedules of cost components. So we need to understand how and when these schedules apply. So, straightforward. Under options A and B, the shortest schedule of cost components applies to the assessment of compensation events, as we know, and under options C, D, and E, the longer schedule of cost components applies to the assessment of all payments, plus the amounts paid to subcontractors. By the way, the shorter schedule could be used for assessing compensation events under options C, D, and E by agreement. Now, even trying to get this point across in a training session to some people who are fairly new to NEC, you see them glaze over a little bit. So my first question really for the audience is, do the benefits of having 2 schedules of cost components outweigh any potential confusion and complexity caused? So I'd just like your thoughts on that. Circle one of the boxes. And if you're not really sure, you'd rather not be black and white about it at this stage, tick the unsure box. Okay. This is fun. Right, so the full list of areas that I've identified, people being confused in the entry of contract data part 2, are the items I'm just clicking down now. I won't read them out because I'm going to address each of them in turn in the rest of this presentation. But hopefully you'll recognise some of these as being topics that you've come across in the past and had a bit of trouble with. So, first of all, tenderers not understanding the contract and inserting TBA, or not applicable, or leaving blank an entry in contract data part 2 that is required by the contract. For example, the percentage for working areas overheads is NA. Seen that numerous times. Now, I don't know how many lawyers we've got in the audience, but I'd maybe like to see some hands in the air. What does this mean when using option C from contract data part 2, when you've got working area overheads not applicable? Does it mean that 0 is paid in respect of those items? Does it mean that the actual mechanism has fallen away and you're actually going back to actual costs now? Or doesn't it make any sense at all? I actually even thought of a fourth option. Perhaps you could even derive what the percentage should be from the build-up of the contractor's target. I don't know. Anybody got a view? Okay, point made. So question 2. Why are people still getting this wrong? Is it because we have got a certain amount of users that will never read the contract and will always be a little bit poor at filling out contract data, or is it too complex? So give me a view on that, please.
It's not the contract data, it's the shift of cost components. So, essentially working our overheads in the first one.
Okay, well maybe we'll come on to that one, John. We'll come on to that one. You might be onto this. Okay. So another one I've seen, working areas description not properly thought through. It is very important to get this right from a contractor's point of view and an employer's, as it directly affects payment entitlements and title to materials. So, for example, in the schedule of cost components, item 11, part of defined cost, wages, salaries, and amounts paid by the contractor for people according to time worked while they were within the working areas. So that's really important. Having said that, the working areas definition also needs to comply with the requirements of 11.218 in the sense it is used only for work in this contract. So you can't put your head office if you're doing a lot of pre-commencement work in the office prior to decamping to site. Possibly you could identify an area of the office, but you can see the sensitivity around this and how difficult this might be. And I have seen people get this badly wrong. So is the need to define and understand working areas fully at contract formation too difficult for users and should be simplified or better explained? Or is it pretty straightforward? I've got my own views. I'll try not to impart those during this presentation. Okay. Right, this is a good fun one. The importance of stating the actual or likely key people, not the best people that may not be used on the job. The scenario is, during the bid stage, the contractor or the subcontractor puts forward the dream team. These are the best in the industry, they're all highly qualified, and they're guaranteed to win the job. Contract gets awarded. Day 1, along comes the actual team. Right? Apparently they have very similar qualifications and experience, and nothing will be a problem. Now, I kind of exaggerate for effect, and it is difficult for contractors and subcontractors. I don't know what the win rate is. Maybe when you tender something, sort of 1 in 2 if you're excellent, 1 in 3. But there is a certain amount of guesswork involved in the team you're going to have on a job, according to whether you're going to win it or not, or which sequence you win different jobs. So there's a degree of sympathy here, and it is tricky. However, the consequences are fairly important. If I take a couple of clauses that kind of interact here. 24.1, the contractor must employ each key person named in the contract to do the job, or employs a replacement person who's been accepted by the project manager. A reason for not accepting the person is that his qualifications and experience are not as good. Okay. The project manager may, having stated his reasons, instruct the contractor to remove an employee. Okay, you can see where this is going. You think, right, what next? 11.225 under option C, D, and E, disallowed cost, includes resources, ... not taking away from the working areas when the project manager requested. Okay, so you could get yourself into some hot water here if you don't at least confront the issue of who is actually going to do the job at the time you sign the contract or complete the contract data that goes into the contract. Okay, so question 4 for the audience. is it unfair or unduly restrictive to require the contractor to provide the key people stated in contract data or equivalent to them? Okay. Right, this is the query raised by John, I think, here. Next item. Working areas overheads, which is one of the contract data part 2 you need if you're using options C, D and E and the longer schedule of cost components. So what's this? This is a charge for overheads incurred within the working areas, calculated by applying the percentage stated in the contract data to the total of people items in 11, 12, 13 and 14. The charge includes provision and use of equipment, supplies and services, but excludes accommodation for catering, medical facilities and the list A to J. I think you have to read this a few times to get your head around what really is included, but it tends to be sundry type of stuff. So I've listed some examples of the type of things that might be included. And I think this is commonly misunderstood, and I think people don't always read the contract. Certainly going back a few years, I've seen contract data just filled out, figures being plucked out of the air, pretty much. So what does the audience think is a typical working areas overhead? Has anybody got a view? If I could see a show of hands who think A, 1% is about right. Right. B, 8%, anybody think? About 8%? 15? 15%. Okay. I'm not going to give you the answer. But here I have. This is from a summary of a genuine tender, an estimator's summary, not filled out in the NEC defined cost and fee type arrangement, but from a second tier mechanical and electrical bid, design and build. Okay. So left-hand side there, you've got the very high-level summary of what's in the estimate, and of course they're aiming to make 10% overhead and profit. On the right-hand side is the working area overheads calculation that would come from that set of numbers. So you can see there's two types of people costs under being the prelims in the working areas and the labour. The direct labour resources. So you can see how that would alter the calculation if you subcontracted that labour instead of doing it in-house. I've extracted the working area overhead type items, being 77,000, and that gives you a percentage of about 1.8%. Now you can see not so much the impact on that working area overhead percentage, but as a percentage of overhead and profit to the job. If you accidentally entered not applicable and it was deemed 0, you'd lose 0.7% of your margin in that situation. If you just plucked a figure out of the air, or if you felt 10% was about right, you might increase your margin by 3.3%. And if you decide to subcontract, instead of holding your own direct labour, you would increase your margin by another 0.5%. So I don't know what that tells us, but it tells us that getting this wrong can make a difference to your bottom line profit one way or the other, and or if you're an employer, quite a big difference to the outturn of the job. Okay. So 3 out of 2 people have trouble with fractions, apparently. So bearing that in mind, is the working areas overhead facility overall a benefit? The idea, I think, is that it simplifies an area where there could be a high volume of small value invoices that would need administrating, checking, auditing, assembling for payment purposes. So you can see the thinking to simplify, but does it overall, is there an overall benefit to that simplification, or does it cause an unnecessary source of confusion? So, okay. So then we flip to options A and B, and if you choose to value compensation events using the shorter schedule, people overheads is the similar type of thing to working areas overhead, but in the shorter schedule of cost components. but it's not identical. It contains all of the items that we saw listed under working areas overhead, but also includes for the use of gas, water and electricity, and for these other items of buying land, compensation, royalties, and a few other things. If we took the same data from the example tender I showed earlier, the people overhead would be about 2.7%, whereas the working areas overhead would be 1.8%. That results from the addition of water, gas and electricity provision mainly. Okay? As I said, on different jobs, different circumstances, these percentages could be a lot different. Now, does this distinct people overhead with a different definition to it than working areas overhead in the shorter schedule provide us with a good enough benefit, or is it another sort of unnecessary source of confusion, do we think? Get your thoughts on that, please. Okay. Now, this is a good one. I hope your concentration span is pretty good for this one, because this is going to get into quite some detail. So, the subcontracted fee percentage under options A and B specifically. Okay? Now, the best way of me talking you through this one was to summarise an email conversation that went between 2 or 3 top industry professionals, which I've summarised and edited, and I've not named anyone to protect the innocent. But the conversation started with someone asking, a contractor wants to know when he prices a compensation event under ECC options A or B, he's got his subcontractor defined cost, he's got his subcontractor fee, which happens to be 25%, and of course he just adds his fee on top, which is I think 6 or 7%. Is that right? And he's saying, I've been told the answer is no, but can anybody explain to me why not? So as is important really, because the subcontractor's fee is 25%, the contractor's fee is only 7%, clearly wouldn't absorb the 25% or leave him with anything on top. So the first answer that came back was, look at the definition of defined cost for options A and B. Defined cost is the cost of components in the shorter schedule of cost components. Tick. Whether work is subcontracted or not. Okay, that's the key words. Then you go to the guidance notes, and they advise that these words mean that the assessment of work which is subcontracted is based on what defined cost is forecast to be paid out by the subcontractor, not what you are paying in total to the subcontractor. Okay? So, all right. So a little bit of silence then. I think there was a 5-minute gap before the next email came in. Not to be beaten, the person who asked the question is, yes, but my point is, what is the cost of a subcontracted person? And let's be clear, the shorter schedule of cost components still expressly talks about the cost of people being included, okay? Is it the amount the subcontracted employee receives, or the amount you can buy that person for as a main contractor? Clause 11 refers to the amount paid by the contractor, which surely includes the subcontractor's fee. Then the answer came back, yes, but clause 26.1, second sentence says, this contract applies as if the subcontractor's employees and equipment were the contractors. Right? And in the shorter schedule of cost components, in the third sentence, the opening paragraph overwrites this for pricing costing purposes under options C, D, and E. Okay? So, everyone clear? I think this might be the one. So, the conclusion is then, under options A and B, the assessment of work which is subcontracted is based upon what the defined cost is forecast to be paid by the subcontractor, rather than what the contractor is to pay the subcontractor. Now, this is really important. This is why, one of the reasons why we've got a separate subcontracted fee percentage to the main contractor's or the contractor's fee percentage. So your subcontracted fee percentage in contract data part 2, when you're using options A and B, must therefore include an amount, maybe an average, for applicable subcontractor fees plus the contractor's fee. Okay? Some difficulties with that, I know. We don't really know who we're going to be employing as subcontractors further down the line. Generally speaking, the smaller and more specialist the subcontractor you employ, the higher the overhead and profit will probably be. So there's a certain amount of guesswork here. So I can see some difficulties, and I can also see two arguments when the express terms of the shorter schedule of cost components, which is a contractor-employer document, talks about the cost of a person. Okay, question 7. Is the application and understanding of subcontracted fee under options A and B clear or confusing? Okay.
I'll just add a little bit to that, which is it confusing or clear with or without using the guidance notes? Because the guidance notes are not a contractual document. And a lot of the explanation and the reasoning that you've got, the answer you got to, was through heavy reliance on the guidance note, not the words of the contract.
Good point, Robert. If you'd like to put that, if you'd like to express a different answer, if you disregard the guidance notes, shouldn't be needed. Okay, we're almost there now with my list of 10 questions. What's this one? Number 8, is it? Number 8. Okay. So option C, D and E, contract data part 2, requires the following entries for design carried out outside the working areas. Of course, design carried out in the working areas will be treated as people or equipment, whatever. So we have to enter a rate for hourly rates for the design employees, a percentage for design overheads, and identify categories of design employees who we want to reimburse travel to and from the working areas. And the schedule of cost components helpfully then says you multiply the hours worked by the rates for those designers, you add an amount for overheads to those rates, and the actual cost for travel. So my question really is, why do you need to add a percentage of overheads if you're putting in rates? And that's a question I often get. Why don't, designers are used to compiling rates that include their overheads. So the question really, and it's not a fundamental one really, is why do we need that extra overhead percentage, or do we? Is there anybody found a use for it? And that is really the question 8. Okay? Right. Number 9. The percentage for manufacture and fabrication overheads. And how many people have used this? But it's an increasing feature and best practice in construction to do more and more assembly and design for off-site manufacture. So we want to encourage the use of this. So we're asked to make 2 entries in contract data part 2. 1, hourly rates for manufacture and fabrication employees. These are the fabrication workers on the shop floor of the factory. Okay? And then a percentage for manufacture and fabrication overheads that no doubt would cover the cost of running that factory or that assembly yard, whatever. And again, schedule of cost component says you times your hours worked by the rates, you multiply up an amount for overheads, and plant and materials are covered by section 3, the SCC, as normal. Now, there are some challenges with this. I've used this a few times in practice. One of the big obstacles I overcome was bearing in mind with off-site manufacture, you're often reducing the amount of labour input right down to a minimum. And the factory overhead can be hundreds of percentages of the fabrication labour cost alone. And that can be really off-putting for clients to understand at the outset of a contract. You also may have different manufacture and fabrication operations. We might have a very simple assembly shed next to the site for simple welding and bracket making. You might, on the other hand, have a full manufacturing facility and factory, which is really part of the company's infrastructure and it's a huge property costs and running costs of that factory. So you don't know which percentage to put in. On major design and build schemes over a long period, you may not have made those decisions at the time of forming the contract either, because you may not even have your full design solutions worked out. So a couple of challenges, but it's an important feature actually. I don't think you can avoid having a feature for off-site manufacture and fabrication in the modern construction world that we operate in. So it's kind of a question, this is the application and understanding of this manufacture and fabrication overheads clear and helpful, or is it too confusing? anyone's used it. And if you haven't used it and you haven't got a view, you know, just click unsure on that one. Okay. So, to wrap up, what is contract data? A complex but important part of a sophisticated and high-performance contract. And it's okay if you read the manual. If you read, there will always be people who won't read the contract and won't read the guidance note. They won't read anything. And of course, they won't get it right. But on balance, this is the final question. Is it too sophisticated? And will some people come off on the first corner who already have read the contract and have read the guidance notes, obviously not fully understood them? Okay. Do we need to simplify, really, is the last question. Taking into account potential loss of functionality if we did. Okay. Well, that's all for me. I look forward to getting your answers. Thanks very much.